Here, this is unfair to the defendants. This is unfair towards the defendant because the defendant won't know, like I said, the defendant won't know the defendant who has to pay I won't say defendant the losing party. Okay, the losing party who has to pay the legal fees may not be aware of the winning party's high legal cost and he has to bear the cost. So this is unfair, and this one also shows high cost. Okay, so this is all. Okay, this is generally known as conditional fee agreement. Okay, and this was allowed before Jackson review. This was allowed before the Jackson review. Okay, so today, post Jackson review, CFA is allowed, but the losing party is not required to pay. You want to have a conditional fee agreement with your lawyer, you can, but you cannot expect the losing party to pay. Okay, can you write this down first?
Mila,
Yes.
why is this so? But isn't it fair that the losing party pays for the cost?
You can pay for the cost. That's why they have not abolished the CFA. CFA is still allowed, but it becomes unfair, Jason, when let's say my ordinary legal fees is 100,000. Now that I'm having an arrangement with you, let's say you're my client, I tell Jason, you pay me $200,000. I will guarantee you I win this case, but you don't worry, the losing party is going to win 200,000. So I'm just making use of your case to double up my income, and you won't bother because you know it is the losing party who has to pay.
Yeah.
The winning case. This is exploiting the system. It's unfair towards the losing party because if you look at the basic contract law principle, only you and I are privy to this agreement, but I'm enforcing it now against a third party. You see here? So that's why because of lawyers like this, legal fees became so expensive because once a lawyer start charging 200,000, that's like a market rate. You are increasing your legal fee standard already. Do you see?
Yeah, that's good.
No, it's not good for litigants. For those who do not have that amount of money, how are they going to go to the... You're denying them the right to court, right?
But they can win the case, right? They can win the case, then they will not need to pay, ma.
Yeah, but not all the time you can possibly win, right? There's so many factors to be determined, correct or not, in winning, losing. So in that sense, if you be very objective, it's not good. High cost, no matter what, is not good. What if the other party uses the same condition and counters suit? You mean the other party means the losing party, is it?
Yeah.
Yes, the losing party
It has for both, ma.
You know what? You lose the case, you cannot have the conditional. The CFA is only for losing party to bear the cost. Any other agreements are not enforceable. CFA is meant, it's something which is accepted by law. It's only meant for the cost to be borne by the losing party. So if you are a losing party, you cannot have an agreement with your lawyer and say, let the winning party claim. Cannot. That is not enforceable.
No, I mean, why they cannot, the lawyer cannot just win the case, and then you don't lose, then you don't get even involved in the case, then you will not lose, ma. You don't even go to court.
That's my point. How do you know that you're going to win the case? Only probability, right? You can only advise
it's a
your client.
mathematical calculation, ma.
Correct, yeah. So the point is,
So you're taking a gamble, ma.
Yeah.
So if you think that you have a chance, then you fight. You have no chance, you don't even need to fight the case at all.
But that's how lawyers work, right? I just want a case, right? So it's now not about the lawyers, Jason. You must look at yourself as a lawmaker. You must look at the public's need. You cannot create a system which will make it difficult for the public to have access. That's not a good system. Am I right or not? If I sell now chicken for $100, one chicken, is that good governance? Yes or no? Will you buy chicken for $100?
That's good
Or
for
can
the
you
farmer.
will you come and tell me it's okay lah? Those rich can eat chicken, the poor no need to eat chicken, just eat vegetables. We cannot go like that, right? We must ensure that the system is same for everyone. All right.
Yeah.
So now the CFA here, all right. When we look at the CFA, there's a student who asked me that question. Can the losing party say that they did not agree to the CFA and don't want to bear the cost? Cannot. That's the problem. That's why the Jackson Review has identified this as a problem. So that's why the Jackson Review wants to work on this. Okay? So the Jackson Review now, like I said, post-Jackson, if you see, today, CFA is allowed, but the losing party is not required to pay. Okay? So the winning party, if you double up the fee, right, you want to pay your lawyer, you pay your lawyer. Do not push your burden to pay to some other person. Okay? Now, additionally, the Jackson Review also implemented damages-based agreement. This damages-based agreement, we call it DBA, okay? DBA now, not in every country's DBA is allowed, but in UK they've allowed this. So this is where we also call this the contingency fee. Contingency fee agreement, and it simply means that here lawyers can take some percentage of damages from winning party. Okay, so which means now the agreement can be based on how lawyers will tell to the client, okay, if we win the case, you give me 20% of the damages as the legal fees. If you don't win, I don't get anything. So this is
More fair.
fair agreement, because this is now between the claimant, the lawyer and his client here. So this agreement, this DBA was implemented through the Jackson Review. But now, let's just pause for a while. Why are we talking about all of this? Because we're talking about cost. We're talking about the cost. One way how this DBA can work, you can manage your legal cost. You don't have to take out from your own pocket money to pay your legal cost. So you give a percentage to your lawyers. Can DBA be exploited? Of course can. Greedy lawyers can ask up to 40%, 50%, right? So that is between you and your lawyer. But the purpose here, the purpose of DBA now is to allow access to justice. Now, even if you have no money, you enter a DBA and then you come to the court. So we are now opening the courts, telling to the people, it's okay, even if you have no money, find these little alternative options and you try to come to the court here. So this is how the Jackson Review fill in the gaps of the Wolf reform. Okay, the Jackson Review has implemented or has enforced access to the courts basically. All right. Now we are on the topic of courts, so I'm just going to cost. Okay. Can I just give you all a minute to copy whatever in the chat box? Then we will move to the next point. Okay, done? Okay, now let's look at this LIP. I spoke to you about LIP earlier. Okay, so when I spoke to you about LIP, I did told you that this is litigants in person. Litigants in person here has increased over the years because they can't afford to pay legal fees. The Mac libel case is a classic example that you can use here. But when you look at this litigant in person here, it is again because another reason. So when we talk about cost here, there are two aspects to cost. A, increase in legal fees or legal costs. That's what I've been talking about all the while, right? Next is the reduction in legal aid. This is another problem that we need to look at. In the United Kingdom, legal aid is given by the state to the people. So, which means if you want to sue your employer, if you have a domestic violence issue, before the Jackson review, you can take money from the state and you can go and initiate your legal proceedings. And that is how many civil cases went to the court. Okay, many civil cases went to the court on this basis. So, can you see or not? Cost, we've got two issues here. This Jackson review, what they did was they made it worse now. As much as the Jackson review allowed access to the court by DBA, they have made something detrimental here, which is the reduction in legal aid. That is through the enactment of LAPSO. This legislation has reduced the number of cases or the type of cases which can claim for legal aid. And the reason why they have done that is because they want to reduce or they want to save the state's funds. So when the state wants to save their funds, their money, at whose detriment here? Litigants, civil litigants. Okay? Now there are so many points for us to look at. I'm going to take you through step by step. Let me address this point first. Like I was saying, okay, this part of the lecture, you write down all these points that I'm giving you, okay? Like I said, before the Jackson review, family dispute, immigration dispute, employment dispute, contract dispute, any civil, two private individuals have dispute, you take money from the state under legal aid, you go and sue, and when you get damages, you don't even have to give it back to the state. All the damages is for you. Good, right? Correct. So, this Jackson review says that, no, the state is spending so much of money, and what actually triggered the state was these illegal immigrants, the terrorists, were taking the state funds through legal aid and they were suing the state under judicial review. So, of course, this was a wake-up call for the state, and they said, no, we are going to control these funds here. From one perspective, one may say, good. It's a good attempt to reduce legal aid for civil cases. Do you know why? Can you tell me why should we limit the number of cases under legal aid for civil cases? Do you know why we should reduce it? Think and tell me. Why must we reduce legal aid for civil cases? Whose fund do you think the state is using? Whose money are these?
Taxpayers.
Very good. Do you think taxpayers' money must be used for private individuals to resolve disputes?
No, should not.
Taxpayers' money must be used for what purpose?
Public.
Exactly. Building tubes, building parks, right? Hospitals. So that was the main reason, one of the reasons given by the state. These taxpayers' monies should not be abused. Some lawyers were also abusing because the lawyers know they will be paid through legal aid. Some cases where is not even genuine cases, can't even go to the court, these lawyers will purposely say, no, don't worry, we can go to the court because they want to get money from legal aid. Funded what? The case. So the legal aid was also abused. So one view is, we can say, reduction of legal aid is good. But, every coin has two sides, right? Now let's look at the problems. If you reduce legal aid, can you think of a problem for me? What can happen?
Those who are genuinely need money, they won't be able to do it.
Sorry, repeat that, Jason.
I mean, those who genuinely have assistance for legal aid, then you won't be able to do it.
Correct. So genuine persons, when they have genuine cases, they are deprived of it, of legal aid. And when you're deprived of legal aid, there's a chain effect. It will affect your access to trial. It will affect your access to courts. So you're not giving these people access to the courts, means you're not even giving them an opportunity to have fair trial. Do you see here the problems here? Okay. Now, I've already analyzed. That was just an analysis that I wanted to do with you so that you appreciate the pros and cons. Now, getting back to this LIP here. So because the cost is so expensive, and when I'm not entitled to legal aid, so based on my chat box, I say, when the cost has increased, legal fees has increased, and when there's reduction in legal aid, it has resulted in high number of LIP. So the problems with LIP, number one is, lay persons, they don't understand the court process. Even if they have a genuine claim, they are not able to establish their case. Okay? Problem number two is, if you look at litigation, you must emphasize on your adversarial skill. It's always about examination and cross-examination. Your negotiation is one of the most informal form, but you had that nervousness, the techniques was taught to you how to negotiate, correct or not? Can you imagine individuals who do not have any form of guidance? They don't know what is the meaning of cross-examination. They don't know what is open-ended, close-ended question. When can I say something? When can I say not say something? These persons may say something which can be detrimental to the case and they don't even know about it. Okay? Collecting evidence, just too much of burden on these litigants here. Okay? All of these will definitely affect fair trial. Law Justice Ryder basically says LIP will not benefit legal advice. They will not have the benefit of getting legal advice. So like I said, you won't know what is the merit of the case. You don't know how to file evidence here. You do not have any idea on the conventional court process. The judges themselves find it very difficult to conduct trial in LIP cases. All right? Look at Lady Justice Black. He said that the burden is actually on the courts when there's unrepresentative parties appear. Because the judge now will be faced with documents which are not organized. They don't know, the judge will have to end up saying, okay, you talk now. Do you have any questions to ask? So it's a burden on the courts because of this cost. So look at what has resulted in the system that we have today. Okay? Now, how can we help these LIPs? We're not going to stop them. Singapore also, you have LIP. We're not going to stop them, but how do we help them basically? So we can have the if you look at the Civil Justice Council, they said that LIPs must have early information and advice here. That means at an earlier stage before trial, if you know that a person is going to represent himself or herself, the case management must be by judges. And in fact, one of the recommendations is more public legal education. I really think this is a brilliant suggestion. Law is part of our lives. Am I right? You don't need to study law to be exposed to law. An ordinary person is exposed to law. Having basic understanding of law is very good. Wouldn't you agree with me? Correct? Teaching the public on their basic rights, the court system, additional educational campaigns, I think is very good. In fact, if you ask me, in our Singapore, we have a lot of work skills related course, right? Law should be one of it, if you ask me. At least let the public take a basic course to understand. Don't have to study substantive law, but basic framework of Singapore. What will a paralegal do? If you want to present yourself, what are the court system? Right, good idea, right? The second, the judicial working group here. This judicial working group, they basically said perhaps instead of following the adversarial system for LIPs, we should follow the inquisitorial approach. So what is the inquisitorial approach? The inquisitorial approach is where let the courts bear the burden, let the courts be fair now and question and cross-examination and, take this evidence and compile them. Perhaps when we adopt the inquisitorial system, there's much more fairness because the judge has the burden. The inquisitorial system is practiced in civil law systems like France, China, Japan, right? The Commonwealth countries, we practice the adversarial system which imposes burden on the respective parties, right? So these are some suggestions as to how we can help LIPs. Okay? Now, we're still at the course discussion, right? We're going to continue with this course discussion now. It's slide number 3, which is legal aid. Okay? Here. Now, let's move to this part. Okay? Do you have any questions that you want to ask me? So far, y'all okay? Okay, now, here we are going to speak about, we're going to talk about legal aid. Before I can get into the LAPSO part, before I can explain to you in this session, I will explain to you about how to approach your assignment. We'll talk about some other aspects of legal aid. So here, we want to appreciate why is legal aid important. We want to know what is the legal aid system in the UK. And we want to also look at the changes introduced by LAPSO here. Okay? Now, firstly, you see ROL here? We're going to talk about rule of law here. Now, when I talk about rule of law here, I want you to know that, okay, rule of law and legal aid, they are interrelated. Okay, they're interrelated in a sense where in some countries, okay, in some states basically, they have stated that the more you have people to have access to justice, okay, it becomes better, you have better rule of law. All right? So in other words here, when access to justice is greater, it simply means your state has better recognition of rule of law here. Okay? So when we talk about better recognition of rule of law, all right, I'm going to talk about this rule of law context. Okay? So let me talk about this rule of law context firstly. So as you can see on my screen here, okay, first, when you have access to justice, the advantage or the consequences is it allows you to protect the legal rights of the public. Okay? You can also hold the legal responsibility of the public. So that's legal responsibility means you are allowing the public to have access. And when I say you allow the public to have access, allow the public to have access in the sense where the public will know that this is my responsibility. If I have any issues, if I've caused harm to others, this is what I can achieve basically. All right. So in that context here, it will be regarded as the your legal means basically. Okay. So rule of law and legal aid or access to justice, they are interrelated. In fact, if I were to refer to Lord Bingham uses legal aid as one of the essence to rule of law. So when he says that one of the essence to rule of law means without legal aid, most civil cases will fail basically. So when we say most civil cases will fail, it will fail in the sense where if you look at the parties in these cases, they will not be able to access courts, right? So it's the same point. You want to enable citizens to assert their rights. So the state is defending them, correct or not? So the state is helping you to uphold your rights. If somebody knocks the claimant is physically injured, a claimant got no money to sue, don't worry, the state will help you to assert your claim, your rights against the person who has committed wrong against you. So that's the meaning of the state is helping you here. All right. So when Lord Bingham says that well-functioning civil justice system, right, it simply means that this is just one of the means here. Okay. So he's trying to say we cannot have excessive cost or delay. When there's no excessive cost or delay, that is the meaning of well-functioning civil justice system. Okay? So, if I'm going to refer to now the World Justice Project. This is a prominent project here, the World Justice Project. This World Justice Project, they yearly do a review and annex to say how your legal cost is related to rule of law. So this is an abstract of their expectation of well-functioning civil justice. It is their idea in this World Justice Project where an innocent and ordinary person must be given the opportunity to address their grievances and obtain remedies in a very peaceful and effective manner. Effective means cost, and there shouldn't be delay here. Okay? So what you can see when we talk about the underlying principle here, accessibility, affordability, effectiveness, impartiality, cultural competence here. All of these are very, very important. So your affordability is where your cost here. Your effectiveness is where we want to avoid delay. So in our class now, of course, we are more focused on the cost and the delay, the cost part. In our civil justice system, I'm not going to talk to you about judicial independence because our syllabus focus is just on one of the issues of civil justice system. Okay? Now, let's do comparison with other counterparts and then we will see whether how effective is UK's access to justice. Okay? So you've got some images from, as you can see here, the World Justice Project will do a statistic, a data, a very detailed report is usually found in their website here. Okay? So only few countries in the world can meet these criteria because very, very difficult, especially for countries like Europe and US, when you've just got, these are big countries, right? So bigger countries, your problems are bigger. But let's look at some big countries like China, for example. If you look at the global ranking of China, it was 16 out of 99. So the 16 out of 99 ranking is actually very good. Access to justice. So they are talking about access to justice here. So when you have access to justice, the point that they are presenting here is there is a rule of law. So China, 16 over 19, 9. Then if you look at Singapore, 10 over 99. Something to be proud about. So you see, if you zoom the diagram, you can see many factors taken into account to see that their rule of law and access to justice is there. Malaysia, 35 out of 99. I don't have to explain that. US is 19. UK is 13. Very good, right? Singapore is better than UK. These are all older reviews. These diagrams are all older. I just want to share the newer or current review here. This is based on 2021. I don't think so the 2022 report is published. Okay, can you see? Rule of Law Index. So again, why are we looking at this Rule of Law? This is 2021, because in this Rule of Law Index, one of the criteria that they take into account to decide whether the country has rule of law or not is access to justice. That's the reason why I have shared this with you. Okay? I repeat again, the reason why we are looking at this Rule of Law Index is because in this World Justice Project, one of the factors taken into account to decide whether the states have rule of law or not is your cost and access to justice. Okay? So look through this, see how can you make use of this information that you have. Okay, this is just an overview.
Under the additional material.
Sorry, no, this is something that I'm giving you now. Look at the chat box, click on the link that I've just shared on the chat box. Do you see the link there, Jason?
Yes, I saw.
Okay, when you click on that, it will take you to this. Look at now page 18. Can you see civil justice here? Focus on this. 7.1, people can access and afford justice here. Right? This is what we are looking at. This is what I meant by your access to justice is a factor to determine whether you're rule of law. So which means your cost is actually a very important aspect of the civil justice system and also the state's rule of law. Alright? So look at it from that perspective.
Right. Xe này.
Alright, now let's get back to this. Okay.
Xe này.
Now let's talk about the other main problems with CJS. CJS means Civil Justice System. So as you read the report, delay is one of it. And when we talk about unequal access due to the population here. So many people in the countries, they do not have knowledge. They don't know that they actually have legal rights to go to the court. Some people, they are wrong committed against them, but they don't even realize that they can take legal actions. Example, a lot of defamatory cases. You don't even realize that statements have been made and these are defamatory. So that's also lack of knowledge a problem here. Okay? So if you want to ensure that the public have access to your, if you want to ensure that the public have access to the justice system, the public can have access to the justice system if the public basically, if the public here have awareness of their rights. They must know how does the law protect them. They must know how does the law protect them. They must also be aware of the procedures. When you go to the court, what are the procedures? They must also know how to redress the system here. How do I approach the system? So this is what we spoke about, the recommendation given by our English bodies saying that creating an awareness, educating the public is very important. Okay? Now, I want you to reflect on these points here. Think from an ordinary man's perspective. Okay? By order, I'm going to give you about a minute. By order, try to think what is the first factor which will deter a person to go to the court. What are the second factor? By your order. Take a minute and then you can share your order with me.
去洗碗先咯。我不理你。不理你，兄弟。你要下来呀，我一早就下来了，你是不是这样？还要我谁嘛？是吧？他只是要我谁嘛
？Okay, if you have your order, you can, your list, you can place it here. You can post it.
是不是？你看，你在这儿，在这儿，在这儿，在这儿。来，这好了。
Cost, publicity, and lack of knowledge, health, cost, fear, lack of knowledge, money, worried about their reputation, time, stress, procedures. Yeah. Okay. Do you realize some of you, your first concern was cost, right? If you ask me to put my list here, I think I'll put cost as the first. We will think. I want to ask you all of y'all a question. Okay? Let's say now you have $60,000 in your bank. Imagine you have $60,000 in your bank. And then let's say now you have a civil litigation. Lawyer is telling 50-50. Legal cost is going to come up to $50,000. Okay? On the other hand, you've already planned to enroll for the LLB, and your legal cost, I think your LLB is what, 30 plus, 40 plus. Let's say it's 40 plus. Okay? You take the money, and where will you invest your money now? In the litigation, or to get the 3 alphabets that you desire, which is LLB? Tell me, what are you going to do with your money?
Get the LLG.
Get the LLB. That's a better investment, right?
I can defend myself.
Make sure you meet the time period lah, because some cases got 3 years, 6 years limitation period, all right? But anyway, you see, the reason why I asked you this question is cost is always a concern. When ordinary civilians have got limited savings, would they want to take their savings and invest it in there's a lot of uncertainty. Some of you use the word uncertainty, right? Correct? The rest of your points are correct. I think Shin spoke about reputation, right? Reputation can work both ways. It can be positive and negative. Sometimes businesses, they're afraid of this negative reputation, so they want to avoid it, right? Now, the reason why I came up with this list is I want you to think that the cost is always at the top priority here. Okay? So now that the cost is at the top priority here, how is the state going to help the people? Because, like I said, one way to allow access to justice is legal aid, right? So LIP, so access to justice is either legal aid or B, what you have is LIP. Okay? Now here, in this LIP, in this access to justice here, please bear in mind, let's now talk about what is the purpose of the state providing this legal aid. The reason why in the United Kingdom, legal aid is given for civil cases is to allow those to enforce their rights and also for defendants to defend their rights. If somebody comes and sue you, like I said earlier, for litigation, you have no choice, right? Litigation, you have no choice means you have to appear in the court. When you have to appear in the court, what's going to happen? You have to appear in the court, you got no money, so you tap on state funds, right or not? So the state will help you, either your claimant or defendant here. But like what we analyzed earlier, this legal aid is at public expense, correct? So when it is at public expense means here the government is willing to give you because the government is committed to rule of law. That's the reason why UK secured, like in 2015, 13 out of 99. Correct or not? So who is vulnerable here? It is the public basically. But over the years, it has become very difficult to manage these funds here. We are promoting equality, we are promoting access to justice, but it's draining the state funds here. Okay? So when it drained the state funds here, this legal aid basically, okay, let's talk what is legal aid. Legal aid, that means it's an aid to your legal fees. That's the meaning here. So we are not giving the claimant the money, and the claimant is not going to take the money as a reward. The money goes to the lawyers. Okay? The lawyers are the one who will be paid, and for what type of cases? Many different types of civil cases. So because it covers, it used to cover a wide range of civil cases. Okay, it covered a wide range of civil cases. So after World War II, the Legal Aid and Evidence Act 1949 was enacted, and they basically says that for just and reasonable claims, or anyone who wants to defend themselves, you can tap from the state fund. It was very, very easy that time, initially, just to help those who are really deprived. Because at that time, not many people want to go to the court like today. Okay? So the test for you to claim legal aid was very, very easy. Then, from 49 to 1980s here, so they created over the years a very comprehensive scheme in the world. It was very a leading example that it's a welfare state. You see, the state is giving you money. This is the process. In 1990s, what they did was, they in fact were so generous, they included legal aid scheme to non-profit agencies, which means even social departments. Okay, your NGOs, even they can claim for legal aid. Right? Very, very generous. Then, the cost of legal aid somewhere in mid-90s reached £2 billion. This now was a wake-up call. The state were like, oh my God, we actually spent 2 billion giving all these individuals, and who actually benefited? Who became richer, you think? Who do you think became richer here? Lawyers, of course. Right? Because whether it's a winning case or losing case, they are still paid here. Okay, this 2 billion to qualify is for both criminal and civil cases. Okay? So then, this Jackson, Wolf Review never say cut down on legal aid. Jackson Review said cut down on this. We need to save the state's money. So the Jackson Review is very interesting because the Jackson Review now has got many purposes. The Jackson Review says, number one, access to justice. And we give you access to justice in a context where I'm telling you that we will give you legal aid, but you need to qualify for legal aid. So today, the legal aid in the UK is based on your means test. Okay? Besides that, if you think you're not qualified for legal aid, the Jackson Review says it's okay, don't go to the court. We've got arbitration. We've got mediation. So the Jackson Review has also promoted ADR. If you go back to my ADR lesson slides, there's a small component on Jackson Review promoting ADR. So the Jackson Review is much more comprehensive because he's saying, first option, you go to ADR first. ADR doesn't work, then you come to the courts. Then you want to tap on legal aid, but you must be qualified to tap on legal aid. Not everyone is entitled to legal aid, basically. Alright? So, if you see this Jackson Review, that means the Legal Aid, Sentencing and Punishment of Offenders Act. So, this is basically called as LAPSO. These LAPSO now has removed, under this legislation, many civil and family cases for legal aid. So you have to start reflecting, how does this compromise with our rule of law? Does this affect with access to justice? Because most of civil cases today no more legal aid. Okay? And these groups who are affected are usually the vulnerable groups. Based on rough statistics, about 623,000 people are no longer have access to justice. They are the vulnerable one. Does this affect the rich? No. Does it affect the poor? Yes. Okay? So these are the problems with the LAPSO. Is that something that you need to identify in your research essay? We're talking about it now. Do you see? Okay? So let's look at the type of cases which no longer qualify. Family disputes such as divorce, custody battles. How is this a problem? How will this make a person vulnerable? Imagine if there's a domestic violence. Wife which is subject to domestic violence want to divorce her husband. She has got no money. How is she going to petition for divorce when she has no money? Right? So you got to think about these kind of cases. The homemakers, you've completely shut them, no more access to courts, because all these cases are no longer part of legal aid. Worst, personal injury and clinical negligence. Again, your target audience here is deliberately vulnerable people. The rich, when there's personal injuries, they don't care. They can pay the money, go to the superstar hospital, get treated, go overseas. But those poor who don't have proper medical means are the ones who are stuck in between here. Again, I'm going to use the Anil Kumar as my hypothetical example. Such a bright chap, right, Anil Kumar? You know how his IQ level was so high. He could have made $1 million as either an accountant, auditor, or as a footballer, right or not? But this Anil Kumar, for those who represented Anil Kumar, did you compromise on your claims? You had to compromise, right? Correct or not? If Anil Kumar were to go to the court, he's a student. Do you think he'll have enough money to pay his lawyers? Maybe no. So then you'd be thinking, what about his parents? Why should the parents pay their life saving for these legal fees? What if his parents has got no money? So there are so many cases like this. Employment dispute, education dispute, immigration, debt, housing, all of these have been shut. So vast majority of civil cases no longer is entitled of legal aid. Is that a problem? Tell me yes or no. Is this a problem or not? I want to see whether you appreciate. It is a problem, yeah? Yeah, it is a problem, right? I want you to reflect on, you are not allowing them to not having them access to justice, basically, okay? Have access to justice. So what is then funded today? So domestic violence is funded, not divorce, domestic violence, forced marriages or child abduction, mental health cases, asylum cases, or when your house is at immediate risk, then you can claim. So very specific subject matter, very, very narrow here. Only these cases will continue to be funded. Okay? So there are two different outcomes of LAPSO. If you analyze it, there are two different outcomes here. Firstly, this is going to be a barrier to justice based on what is written on red. As soon as I see I'm not entitled to legal aid, I'll stop my case there. I'll say, forget it, I'll just live this life. That's one biggest problem that we have. The second problem is it's going to result in LIP. And I've already spoken to you about the problems of LIP. Okay? Now, you see these problems, right? What are you going to do? You got to now go and research on these two problems further for your research essay. Don't just take these two pieces of information and expect to cover 2,000 words essay or 2005. Explore more, work on this, find what are the other problems as well. I'm just showing you the road I'm telling you, take the road. Okay? How did they determine the priority in what gets funded and what doesn't? I'm coming to that shortly, Shin. There's a means test. I'm going to introduce the means test shortly. Okay? Now, what I've just addressed, the subject matter. The answer to your question is the means test. Okay. Now, is there a right to legal aid? Before we talk about the right to legal aid, I want to answer Shin's question. So I'm going to share now some link again. Sorry, wait. Okay, please click on this link. This is from the government.uk legal aid means test. Okay, so the means test. So you need to qualify. Firstly, you need to make sure that the subject matter is covered. Okay, assuming the subject matter is covered, that doesn't mean you're automatically entitled. It could be a domestic violence issue, but you may not be entitled to legal aid. So you need to look at this income test here. Your income, your family circumstances, such as number of children, your living cost and mortgage rent here. Okay, so now look at this. This is the calculate the weightage of your income basically. Then the age of the children, how much weightage will be given, and then how your adjusted income and so on. Okay, now don't panic. Don't panic like, oh my God, do I need to do all this calculation? No need. Your assignment question does not require you to talk about this calculation here. You just need to now review the means test to see is this means test reasonable or not. Okay? There are a lot of articles about this. Okay? Go and do your research. Okay? Subject matter is one area of research to criticize LAPSO. The second research area will be on the means test here. Okay? And of course, you must know the two consequences of LAPSO. So expand. I've given you now some areas for you to discover the problems. If you want to score A, write more. Okay? Write more. Show that you have taken independent research. Now that you know how to access Westlaw and LexisNexis and other legal platform, I don't only want to see Google articles in your referencing. No, because this is the first time you're with me, right, for research essay. No Wikipedia references. No lawteachers.com. All right, all of that is laymen will do research and read from that. You are doing a proper legal research. You got to go through government website, reports, publications. Okay, all of that must be a proper cited footnotes and your referencing. Articles that you read, all of that can be part of your referencing. That means articles means legal articles, published articles and so on. Okay, now let's talk about, since now substantially legal aid has been removed, this is something that I asked you earlier also. Is this even a right to begin with? Can we say that now that you've deprived me of legal aid, I no longer have access to courts, and this is violating my human rights? Because access to courts is one of your human rights, okay? The word CL here stands for common law, okay? CL stands for common law. Common law has always created right of access to courts. Remember we spoke about natural justice? This idea of natural justice is an old term which is used by our common law judges, which is few hundred years old, by saying that common law courts is open to everyone. Everybody must have access to common law courts. So this is one of the human rights in the UK, is for the people of the UK to have access to courts. Okay, qualified access to courts is one of the rights developed by common law courts. So how do you have access to courts? If you want to exercise these rights, you must have access to courts, right? How do you have access to courts? So this access to justice, okay, is having access to courts. through legal aid, and of course, you must have access to legal advisors. It's all pertaining to your access to justice. Okay, you must have access to the court, you must have money, and you must have a right to speak to your lawyers. Get your lawyer's advice. These were traditionally established by common law as your constitutional rights. If you have this, there is rule of law. Okay, so this is the scope of your common law rights. And if you look at European Convention on Human Rights, on the other hand, they say that legal aid must only be given for criminal cases. Compulsory legal aid for criminal cases, and I think you know why. In criminal cases, your sanction is so harsh. So when the sanction is so harsh in criminal cases, what happens there? There, in this case here, for these criminal cases, must make it compulsory. So in the UK, LAPSO still makes it compulsory for accused to have legal aid. What has been reduced is for civil cases. So UK has not breached Article 6, Paragraph 3. Okay? For criminals, your legal aid is still there. So now, is legal aid a right according to ECHR? Let's look at this case of Aryan Island. This is a very sad case. I've shared the link here. You look at my notes here. I've shared the link for you to read. Okay? It's a case about how this lady could not have access to justice because she was denied legal aid. So the Irish government said, so what? She can represent herself. She still have access to justice. But the European Court of Human Rights says, now, the main purpose of Article 6, which says that everybody must have access to courts, means we want to make sure that there's an effective outcome. Everyone have fair access to the courts. Okay? But in legal aid in civil proceedings, this civil proceedings can be very, very complex. Especially the courts commented that the Irish system is so complicated, the common people do not have legal understanding, cannot represent themselves. So in this case, the European Court of Human Rights said that not giving her legal aid is a breach of fair trial, although it's a civil case. Okay, although it's a civil case, they said that you cannot expect her to present herself. The system is very complicated. Why am I now discussing this case as my closing case? Because in UK, we have ended up in LIP today. This is something, this Ireland case, this LIP took place in 1979, and the Court of Human Rights says, no, you can't just expect people to go and present themselves in the court and say that they have access to courts. The system is so complicated. Read this case. Read this case. Understand why was there breach of Article 6 when there was no legal aid given for civil cases. Okay? And I want you to think about the implication of all of this. All right? The government responded, our UK government responded by saying that, well, common law says you must have access to courts. We have not deprived anyone of access to courts. The government responded by saying that access to courts and legal aid are two different ideas. I repeat, the government, UK government is saying access to courts is still there. Legal aid has got nothing to do with your access to court. Okay? I've also shared the report here. You can actually just copy this link here. Can you see? Publicationsparliament.uk, right? Ask yourself whether do you agree with this or not. Okay, these are all some readings that you must do. Now, do you know why this is called research essay? You've got to really have to do some research. Okay, now with all this information still fresh in your mind, I want to take you through your assessment question. Let's see what must you discuss. Okay. So let's look at the question here. Quote first, meaning and scope of legal aid has altered with the enactment of LAPSO. Okay, so you have to deal with this first part. Do you agree that the meaning and scope of legal aid, okay? Do you agree that the meaning and scope of legal aid has been altered after LAPSO? Okay, answer this question first. I wrote scope in caps because you need to explain and evaluate. So you must explain why legal aid scope has changed. Some part will be very brief. After that, you must be very evaluative. This is why it has changed. Okay, for example, you can explain that how to qualify for legal aid, only selected cases are qualified. That is descriptive, right? That must be very brief. Then, I want you to analyze the consequences of that. That is the evaluative part. What has resulted because of this alter here? Okay? There are now many areas of civil law outside the scope of legal aid. Didn't we cover this earlier? Right? Laws outside the scope of legal aid. We just went through that, right? Do you see? So that's what I said you must address. Okay? Question now, that's the quote, question. Discuss the changes introduced by LAPSO. Analyze the consequences of the changes to the civil justice system. Okay. I highlighted blue and pink. Blue is the descriptive part of your answer. Explaining the changes is descriptive, the one in blue that I highlighted. Pink, the one that I highlighted, is the evaluative part. You look at the question, I just interpreted the statement, right? The question is based on the statement. So that's what you must do. So, will you focus more in your answer? Will you discuss more about the blue highlighted part or the pink highlighted part? Where will you give more emphasis? Where will you give more emphasis? The blue or the pink?
Pink.
Very good. You do blue, you're getting a bare pass only, that's all. Okay? Now, how to score A? Everybody is going to do this, right? How to score A? So, this is where you have to demonstrate your research skill by looking at post-Jackson reviews. Jackson review has been implemented. But after the implementation, that means, post-LAPSO. Post-LAPSO, you must go and read on the reforms, proposals, recommendations. Okay? Go and read on all of this. That will be the third part of your answer. That's not written in the statement, but you got to address that to ace your paper. Because you've told me now in blue what is the system. Pink, you've evaluated the pros and cons. So there's a problem, right? What is the solution? What is the government recommending? There's a lot, There's a lot on that. Okay? So can you see how your answer structure must flow? Explain the changes, evaluate what is the current review. So go through your additional material folders. There are some documents and additional materials. Read framework your answer outline. I hope you can already see the outline and you can start answering your question. Do your research, compile your materials, and start working on this. Okay? Now, do you have confidence to approach this question? You get an idea? Why no? I've been talking since 6:30 and you said no. Thank you, Constantine. The rest of you?
Miss Nirmala,
Yep.
after the class over, I just want to speak to you something.
Sure.
You and me only. Because
Sure.
this is my own research, so I don't want other people to hear it.
Okay, sure.
It's on this topic actually.
Okay. The rest of you, can you see the outline, the framework? Ivan? Okay, I know Amelia can see. If you're shaking, you're nodding your head there. I can't see, your cameras are turned off. Daunting, Shin, this is just the first assessment, All right?
Yes, thank you.
Okay, then, do you see the second question, the 500 words? Identify and summarize the Legal Aid Bureau application process for legal aid and assistance in Singapore. You just have to go and search Legal Aid Bureau application process for legal aid and assistance in Singapore. Just go copy this in your Google. There's a website will come out. I can't give you the website because it's like then me giving you an answer. Just summarize it, okay? Make your arguments concise, okay? So you can just write the following are the procedures. A, you write in long sentence B, okay? So for example, B, to submit application form 33. Don't have to explain what is form 33. Form 33, do you understand? The case will be reviewed by the president. Just write like that. Do you see or not? You get an idea? So that's how you will cover the 500 words basically. Understand, Jack? Okay, so you understand, you read up the process first, then you can merge these processes and say Form 33 will be submitted by the applicant and reviewed by the president. Then you can explain the next process. So you can actually possible to do it. Okay. So this one is very easy. It's very descriptive. There is no evaluative, nothing all. They just say, just identify and summarize only. Okay, guys? So the most important is this part. So I want to gently remind all of y'all, from now, from 9:48, you must start working on this assessment 1. Okay? Assessment 2 and assessment 3 will be addressed in the upcoming classes. Alright? So in our next class, you see now I've covered the lectures for lecture 3. My next class with you is my next class with you is ADR, civil proceedings, and how to write an essay. So we can cover that. Maybe I can just cover one of the section there. After that, lecture 5 is on criminal justice system. And then lecture 6 is on your juries. 7 will be on mooting, right? Is 7 on mooting? Yeah, 7 on mooting. Okay. So maybe for your benefit, what I can do, I can bring the mooting lectures in advance, and then I can push the criminal justice system to much later. All right. But let me give you some time to digest on this LAPSO first. All right. I don't want to just like bulldoze all the assessment to you. So maybe in my next class, I'm definitely going to cover ADR, civil proceeding, and how to write an essay. Okay, I'll go through that while you do your research on LAPSO. Then in the following class, perhaps I will move towards mooting. But you must understand why this lecture sequence is this way, because we need to cover the lectures on the on the legal system first. Then only we can cover on the substantive law. Okay, but I don't mind to just tweak here and there a little bit so that you can benefit out of it. All right, guys. Okay. Now, if you look at your seminar 3, you have some questions to be addressed there. So seminar 3 is basically, you've been asked to, can you see here or not? Present the problems of LAPSO here. and identify the key problems and present your views. Basically, you need to present your views. You'll be given 3 minutes to present your views during the seminar session. Your tutor will provide a general feedback, which I will provide a feedback here. Then, of course, there are other questions here, okay? But I just want to do this seminar question because this will help me to appreciate, okay? This will help me to see whether do you understand about it or not, okay? So in my next class, all of you do a research. After your research, we will just spend maybe about few minutes trying to identify the problems of LAPSO. We'll discuss that, and then we will move to lecture 4 basically. Okay, so lecture 4, as you can see, it's a case on ADR. Let me just share what is that. So it's a case on ADR, okay? So, oh God. When it's a case on ADR, it's a case where you're looking at, as you can see, we are not going to repeat what we have gone through. Okay, we are not going to repeat what we have gone through, but I'm going to explain to you about how this ADR system here, okay? When we speak about this ADR system, the ADR system is different. It's different in the sense where here we'll be talking about compulsory ADR. How parties are forced to go through ADR. And when I say parties are forced to go through ADR means they have no choice in the sense that they are forced. So when I say forced, you are telling these parties here, you don't have access to the courts, okay? I'm not going to allow you to go to the courts because if you were to go to the court here, it will result in, okay? It will result in how the parties here will spend a lot of time, no legal aid, so many issues and so on. So for these reasons, for these purposes, ADR has become compulsory. So of course, as you know, there's pros and cons when ADR is compulsory, right? So that's the main theme of this lecture. Okay, so that's what we will mainly be looking at, okay? Okay. So now I'm going to do this lecture with you next week, okay? Now I have a student who has asked me to repeat it on ICT. Okay, this will be the last time I'm repeating on ICT, so you can take a video of what I'm going through, or like I said in my last class, you can write down of what I've asked you to go through, all right? So for everybody's benefit, once again, wait, it's going to take time for me to log in. So let me just show this one here, and then I'll mark your attendance, okay? Okay. It's okay, no problem. Okay, now for those who missed it last week, just take note. So I need everybody to see. If you think you'll forget, you can take video recording of what I'm doing or just write it down, okay? Now, as you can see here, you go to library, okay? At this library section here, click on this. You go to links, click on find resources, okay? When you find resources, Okay, what is that? Then you move to data. You want to find books, you go to books here. Under these books section, okay, you click on books, right? You go and click here on the left screen. Library and learning resources. So you can type the book's name here. Okay, then you can find there will be e-copy. You can read the e-copy. If you want to go through, I take you back again to this main page. You want to find cases. You go to databases. Databases here. Scroll down. You will have A to Z. You click on this. And then I usually use Westlaw, but you can try others if you want to. So if you click on W, Westlaw here, click on this. Then I think you need to log in again. And then from here, you can download your cases and you can download judgments. Wait, it's taking time. Okay. Okay. So you want to download cases, you go and click. You see on the left side of the link here, you click on cases. Just click on case search. You can type the name of the cases, right? And you can download the judgment from there, or you want to find cases on subject matters, subject or keywords, you can type here, okay? You want to find journals, just click on journals, go on journal search. You just type the name of the journals that you know, or if you are researching on a subject matter, you can just write the keywords here. All the articles which had used these words, your keywords, will appear. Okay? Then you can actually download them and you can read them as well. Okay? So it's actually very easy, very user-friendly. You just need to know where to go. Once you're done with that, then you will be able to access it. Okay? So everyone, I hope I know some of you told me last week that you can't log in. So I hope you can log in now. Yes, Yisheng?
Hi, just a quick question. Sorry, it's not about the digital library. So if I'm jumping the gun, I can ask you.
It's okay. No, go ahead.
Okay. Leon, did I hear you correctly when you said that for this paper, we should really be just focusing on the cost aspect of legal aid rather than the other considerations that you outlined in one of the slides just now? I was just hoping to clarify if I heard that correct.
Yes, because it's written in your question itself. Do you see that?
Okay.
Scope of legal aid.
And
the pink one I just highlighted now.
Mhm.
So that's the reason why you only have to focus on legal aid.
Sorry, I meant the cost aspect of legal aid. Was that really what you were trying to get us to focus on? Because there are other factors apart from cost, and should the one factor that we really be focusing on, is it cost?
The cost on legal aid.
Yes, the cost as in COST.
Yeah.
That should be what we should be focusing on for this essay.
Correct.
Would that be?
Correct.
Okay.
Correct.
Got it. Thank you.
Okay, welcome. Any other questions? Anyone else with any other questions? No? Okay, so don't forget to start working on it, your work. Okay. Now I'm going to mark your attendance, and then for those who have questions, you can stay back. I will answer your questions, okay? Okay, Katrina, are you here?
Yeah, here.
And then Constantine is here. Rajaraman?
Here, madam.
Brandon is not here. Ku is here. Tristan.
Present.
Okay, and then Shankari.
Present.
Edison.
Yeah, here.
Lowyishan. Okay, and then Jesslyn.
Yeah.
Lo Yisheng is here. Prem is here. Lucas here. Lo Tiang is here. Li Jinling is here. Abu Lim is here. Sadiq here. We come in, Andrew?
Yeah.
Okay. Amelia here. Michael here. Ivan here. Kushbu?
I'm here.
Okay. Jocelyn is here. Azira here. Shamila?
Yeah.
Mervin is here. Then Jijun.
Present, madam.
Okay. And Sophia?
Yeah.
Okay. Jason here. And Shin is here. Ahmad is here. Jasmine here. Last is Rizwan here. Okay. I've marked everyone's name. Absentees. I think all of y'all are present except for those who are not in the program. Lochini and Brendan lah. Okay. Yep. Have I missed out any of your names? No. Okay, so happy conducting research. Anyone with questions can stay back. Otherwise, I'll see you all in my next class. All right, guys? Daunting research. Start the research now.
Thank you.
Welcome. Oh, did you also
Thank you.
mention?
Good night.
Yeah, I spoke about that Jinling. Then I thought that myself I just give you with the dates and time. No rush also, right?
You say you'll be sharing us the name list, right?
Yeah, then I thought about it. After that, I might as well just get the confirmed date and give you all the complete document. Okay? Unless you're too eager.
Myla, we not choose our own partner.
You want to choose your own partner?
Isn't it a better idea that we know each other better?
I know, but the problem is when I allow you to choose your own partner, some will be left out and there'll be so many issues. I know you're going to choose Sophia, right?
Some may end up with no partner.
Yeah. But don't worry, Jason. I can read your mind.
Wow, no wonder. I mean, there sometimes there could be partners who does not even turn up. Why do you want to partner with them even?
Don't worry, Jason. I know all of y'all. I know how to pair it up. Okay?
No.
And trust me, we'll be in safe hands. Okay?
Wow. See, I got somebody who agree with me.
I know, but the problem is like it's opening a can of worms lah. If I give everybody choice, there will be like what Shin said. You're going to have people without partners, and there's going to be too many issues. Then I will have one student saying I want to partner with Jason. Another student also will tell me no, I also want to partner with Jason. Okay, so I want you to understand from my position.
Yeah, I understand that.
Yeah, so it's better if I do it. Yeah. All right. Okay. Anything else, Jason?
I think no.
No. Okay. Welcome.
Thank you. Good night.
Good night. Good night, Jocelyn.
Bye.
Bye.